assessing the risk of harm resulting from a particular activity or policy by reference to general causation, the cumulative impacts of other activities, whether of the relevant state or a third state, must be taken into account. Returning to my river example, before State A permits the release of the metal pollutant into the river from a factory on its territory, that state would clearly be obliged to consider the already accumulated levels of the metal pollutant in the river, as well as any reasonably foreseeable future levels of the metal pollutant to be emitted by State A or any other state. And intuitively, the same applies to greenhouse gases. And this approach is reflected in the decisions of ITLOS and the Inter-American Court of Human Rights. Third submission, as to the separate question of specific causation, that is, whether a specific act of State A in fact caused a specific identifiable harm in a given other state, that specific causation is relevant at a subsequent stage of the invocation of responsibility when reparations are being sought and determined. That was a point squarely made by ITLOS in the context of Article 194 of UNCLOS. Now, that subsequent stage would clearly be a fact-specific assessment, and several states agree that a threshold of but-for causation would be inappropriate. One could pose hypothetical cases involving large-scale emissions where a sufficiently quantifiable harm emanating from a specific project or a specific state could in fact be evidenced by best available science. And we have seen domestic courts engaged in aspects of such quantification. But the key point for present purposes is this: any difficulty in establishing specific causation in certain claims for reparation is not a principal basis to foreclose the applicability of the prevention obligation in this context altogether. In these proceedings, pragmatic guidance from the court is key, and with that in mind, I focus now on one hard-edged, concrete aspect of the prevention obligation, the assessment obligation. ITLOS described this as a crucial application of the prevention obligation, vital for identifying risks of harm before they materialize, as well as ensuring public awareness of the impact of activities and public participation on what is or isn't done to our planet. To cite the Apex Court of the United Kingdom earlier this year, you only care about what you know about. With reference to the well-established jurisprudence of this court, Belize identified 3 stages to the assessment obligation as follows. Stage 1, identifying an activity having the potential adversely to affect the environment of another state. Stage 2, ascertaining whether the activity poses a risk of significant transboundary harm. Stage 3, where such risk exists, conducting the assessment itself. And the application of each stage to greenhouse gas emissions is addressed in detail in Belize's written submissions. Today, I highlight the following points. First, it is well established that the assessment obligation applies to specific activities planned to occur within a state's territory or otherwise within the state's jurisdictional control. Applied to greenhouse gas emissions, it includes activities planned by a developer or contractor, including private actors, as well as a state's broader policy decisions to allow relevant emitting activities. Second, as to the threshold of a risk of significant transboundary harm, this denotes an objective assessment referring to a possibility rather than a likelihood. The due diligence standard takes into account both the degree of the risk of harm and the gravity of the consequences if the risk materializes. With respect to greenhouse gas emissions of particular relevance, of particular significance are A, the best available science as reflected in the IPCC reports, and B, the precautionary principle. And there must be taken into account both sensitive receiving environments, such as Belize's coral reefs, as well as indicated earlier, cumulative impacts. My third point, The information contained in the assessment must be sufficient to allow informed decision-making in the state of origin and to meet the needs of potentially affected states in understanding the degree and seriousness of the risk of adverse transboundary impact. Whilst not authoritative, Appendix 2 of the Espoo Convention offers useful general guidance in that regard. Fourth, the states must notify in good faith potentially affected states, where that's necessary to determine the appropriate measures to prevent or mitigate the risk, as was expressly confirmed in the certain activities case. The existence of this obligation flows from both the nature of the requirement to exercise due diligence and the duty to cooperate. Finally, the obligation to undertake the assessment is a continuous one, with monitoring of the relevant activity conducted in accordance with the best available science, so as to evaluate the actual, as opposed to predicted effects of the relevant activity. Flowing from the nature of the requirement to exercise due diligence, the duty to cooperate, and the critical role of enhanced transparency and public scrutiny in the prevention of environmental harm, the monitoring reports must be made public. In conclusion, an opinion affirming the applicability of the prevention obligation to the present context, including an elucidation of the causation analysis, and guiding states by identifying the hard-edged contours of the assessment aspect of that obligation, would be a concrete outcome of real pragmatic significance. Mr. President, members of the Court, that concludes Belize's submissions.
I thank the representative of Belize for their presentation. I now invite the delegation of Bolivia to address the Court, and I call His Excellency Roberto Calzadilla Sarmiento to the podium.
Mr. President, members of the Court, it is a great honor to appear again before you and to do so on behalf of the plurinational state of Bolivia. Mr. President, climate change stands at the defining challenge of our time and the gravest threat facing humankind, including future generations. With global temperatures already approaching the critical 1.5% threshold, we confront an unprecedented crisis that will shape the fate of generations to come. Its worst consequences are borne disproportionately by those who have contributed less to its course, making this not merely a matter of scientific fact, but fundamentally an issue of justice. Bolivia recognized that the structural causes of climate change stem from the current anthropocentric model, particularly the capitalistic system of development that has dominated the last 2 centuries. The system has precipitated the present climate crisis, violating basic human rights, disrupting Mother Earth's life cycles, leading to ecosystem collapse, upending traditional ways of life for hundreds of millions of people worldwide, and intensifying global hunger and poverty. The question of state responsibility for climate change cannot be divorced from this reality. Not all states bear equal responsibility for anthropogenic climate change, yet developing states, particularly as Bolivia, a landlocked developed country, bear a disproportionate burden of its consequences. This inequity fundamentally undermines the human rights of present and future generations. Mr. President, Bolivia fully maintains all positions articulated in its written statement, to which is respectfully refer you today. We will endeavour to assist the Court today on 5 central issues. First, we will demonstrate that this Court possesses not only the jurisdiction, but indeed the duty to render an advisory opinion on these questions, which are manifestably legal in nature and of paramount importance to the international community. Second, we will examine The relationship between climate treaty obligations and other obligations under international law, establishing why compliance with climate treaties alone cannot absolve states of their broader international obligations. Third, we will address the principles of common but differentiated responsibilities and respective capabilities, demonstrating its status as a fundamental principle of general application in international law, and that must inform the interpretation of all climate-related obligations. And finally, we will examine the duty to cooperate and its specific implications for climate finance, showing how meaningful cooperation through climate finance constitutes not a discretionary act, but a necessary implementation of established legal duties. Mr. President, members of the Court, given the broad consensus among participating states regarding the Court's jurisdictions in this matter, we see no need to belabor this point. The questions before the Court are manifestly legal in character, and the General Assembly's competence to request this opinion is clear. However, we would note that recent developments at the COP29 in Baku demonstrate precisely why the Court's guidance on this question is so vital. The ongoing struggles to secure financial commitments for climate action and the bitter division between states of responsibilities and obligations illustrate how the international community urgently needs clear legal guidance on questions of obligation and responsibility. In these circumstances, Mr. President, we submit that not only does the Court have jurisdiction, but the exercise of its jurisdiction is particularly appropriate and necessary at this moment. Mr. President, I turn to the fundamental question of the scope of states' obligations in respect of climate change. The first question posed to the Court requests it to identify the obligations of states in respect to climate change. Bolivia notes that the UN Framework for Convention on Climate Change regime has the fundamental and primary role in addressing climate change issues for the wide range of sources from which climate-related obligations stem. These obligations arise not only from the climate change treaties, but also from customary international law, human rights law, and other international instruments. It must be recorded that some of the participants appear to object to the breadth of the request, arguing that the climate treaties alone apply to the phenomenon of climate change. Others have argued that the climate treaties constitute lex specialis, with the intended implication being that compliance with these treaties should be considered in all cases sufficient, irrespective of the existence of other obligations. These views are untenable for three questions. First, the UNCCF and the Paris Agreement themselves acknowledge the relevance of the other obligations, indicating they were designed to complement, not replace, existing international law obligations. Second, the principle of systemic integration requires that treaties be interpreted in harmony with other applicable rules of international law. This means that obligations under the climate change regime must be read consistently with fundamental principles such as the principle of prevention and the protection of human rights. Third, even if the climate treaties were to be considered lex specialis, which we submit they are not, any displacement of obligations sourced elsewhere would occur as a result of a conflict. No such conflict occurs here. As a result, it cannot be said that compliance with climate treaties may absolve states from their other international obligations. The recent advisory opinion of the International Tribunal of International Law of the Sea confirms this understanding, insofar as it is rejected the notion that compliance with the Paris Agreement alone may satisfy states' obligations under UNCLOS. Different legal regimes create distinct but complementary obligations regarding climate change. Mr. President, this conclusion carries several important implications, of which Bolivia wishes to highlight three. First, different legal obligations may impose varying standards of conduct which should be interpreted in conjunction to address climate change. With the UN Framework Convention on Climate Change regime playing a primary and fundamental role. Second, the historical responsibility for climate change remains relevant under general international law. Third, cross-cutting principles of such as the common but differentiating responsibilities must be understood to operate across these different legal frameworks. In conclusion of this point, Mr. President, Bolivia submits that the Court must consider the full spectrum of international legal obligation bearing on climate change, recognizing that compliance with one set of obligations does not excuse the compliance with others. In the Nuclear Weapons Advisory Opinion, the Court affirmed that this principle is part of the corpus of international law relating to the environment, and recently in ICLOS has confirmed that it applies to climate change. In its recent advisory opinion, the Tribunal has confirmed that in the context of UNCLOS, Article 194, paragraph 2, imposes upon states parties a particular obligation to take all measures necessary to ensure that anthropogenic greenhouse gas emissions under their jurisdiction or control do not cause damage to other states and their environment. The Tribunal emphasized that this amounts to an obligation of due diligence. The key question is whether this established principle of international environmental law applies to greenhouse gases emissions and more broadly climate change. While most participants agree that it does, some argue that it does not on the basis of three main objections. None withstand scrutiny. First, some argue that the global nature of climate change precludes the application of prevention principle as traditional applied to bilateral transboundary harm, that this argument fundamentally misunderstands the nature of the obligation. The principle necessarily encompasses all forms of significant harm, regardless of the precise pathways through which that harm occurs. Moreover, the global character of climate harm strengthens rather than weakens the application of the prevention principle. If states must prevent localized transboundary harm, the harm which threatens the rights of one state, they must fortiori prevent contributions to global environmental damage that threatens the fundamental rights of all states. Second, it is suggested that the cumulative nature of emission negates individual state obligations, inter alia because the resolution of climate crisis requires collective efforts and cooperation. These two must be rejected. The principle of prevention has always encompassed forms of harm resulting from aggregate conduct. Moreover, the objection is strictly speaking a classification error. Obligations do not become collective by virtue of their breach contributing to cumulative harm. Thus, it cannot be said that the nature of the harm absolves individual states of their obligations. Understanding those obligations within the framework of historical responsibilities and the principles of equity and common but differentiated responsibilities. Third, this understanding is reinforced rather than undermined by the fact that substantive obligations are accompanied by procedural obligations, because it is only through cooperations that states can effectively manage and prevent environmental risk. Procedural obligations such as those of cooperation, notification and consultation are vital for protecting shared resources that can only be safeguarded through continuous cooperations. But the Court has emphasized that prevention requires cooperation precisely because environmental challenges cannot be addressed in isolation, but because shared challenges absolve individual states of their primary obligations. Fourth, Some states point the difficulties of causation and attribution. The complexity of climate science cannot be used to evade obligations under international law, and in any event, matters of causation and attribution must be examined in relation to the relevant rules concerning the consequence of the breach of primary obligations, which Bolivia submit are to be found in the law of state responsibility. On the contrary, causation and attributions play no role in determining the existence and scope of primary obligations. Mr. President, I turn now to the principle of common but differentiated responsibilities and respective capabilities. The question of the legal status of the CBDR principle has generated significant debate. Some states contend that this principle operates exclusively with the framework of environmental treaties, particularly the climate change regime. Others maintain that it may instead inform obligations across different legal regimes. Bolivia aligns itself with this later view. Two key considerations supporting recognizing the common but differentiated responsibilities and respective capabilities as a principle of general application in international law. First, these principles may be seen as a specification of the principle of equity. It operationalizes the recognition that states which have contributed differently to the climate crisis and which have different capacities to address them cannot be held to identical standards. Second, there is growing recognition that this principle is applicable to the question of climate change beyond the scope of environmental treaties. For example, the International Treaty on Law of the Sea recently confirmed that while the UN Convention of Law of the Sea does not explicitly refer the principle of common but differentiated responsibility, it contains elements common to this principle. Similarly, the principle has been found to shape the understanding of human rights obligation in the context of environmental protection. The implication of recognizing these principles' broader status are significant. It means that the principle must inform the interpretation of all obligations relevant to climate change, not just those under the climate treaties. In this connection, Bolivia wished to draw attention to two specific points. First, CBDR-RC affects the assessment of due diligence standards across different legal systems. What constitutes appropriate measures to prevent environmental harm necessarily varies according to both states' historical contributions and present capabilities. The standard expected of states must reflect both the differential contribution to environmental harm and their varying capacities to address it. In its advisory opinion, the IT clause confirmed that the scopes of measure to reduce anthropogenic greenhouse gas emissions may differ between developed states and developing countries. And while all states must make mitigation efforts, developed states should continue taking the lead. This differentiation is particularly relevant for landlocked developing countries such as Bolivia, whose historical contribution to climate crisis has been insignificant. Second, may be relevant not just for the assessment of the obligation of state in respect of climate change, but also for the consequence of the breach. Mr. President, on this point, some states emphasize that this principle necessarily influences how state responsibility operates in the climate context. They argue that responsibility cannot be assessed without reference to states' historical contributions to the problem. Some participants point to the paradox of applying identical standards of responsibility to states that have contributed vastly different amounts to cumulative emissions. Other states strongly contest and link between these principles and state responsibility. They argue that the common but differentiated responsibility is forward-looking and cooperative in nature, designed to facilitate future action rather than assign responsibility for past conduct. These states maintain that the principle cannot modify the established rules of state responsibility, which they argue operate independently of states' different circumstances or capabilities. Bolivia submits that the truth lies between these extremes. The principles neither displace nor overrides the law of state responsibility. The basic elements required to establish responsibility, breach of an obligation, attribution and causation, absence of circumstances precluding wrongfulness remained unchanged. However, CBDR-RC necessarily informs how these elements are assessed in the climate context, including on the basis of the historical contribution to the harm. This is particularly relevant in three ways. First, in determining whether a breach has occurred, the content of the primary obligation itself should be assessed on the basis of the principle of common but differentiated responsibilities. Second, in assessing causation, the historical dimension of greenhouse gas emission cannot be ignored, as it forms part of the factual matrix against which responsibility must be determined. Third, in considering appropriate reparation, the principle of full reparation must be understood in light of states' different capabilities and circumstances. This understanding better reflects both the reality of climate change and the fundamental nature of this principle of common but differentiated responsibilities as a specification of the general principle of equity. It allows for responsibility to be determined in a manner that accounts for historical contributions while preserving the essential features of the law of state responsibility. Third, these principles inform the duty of cooperation, to which I now turn, Mr. President. When states cooperate to address global challenges, they must do in a manner that accounts for different levels of responsibility and capability. This requires operate independently of specific treaty provisions. The duty to cooperate stands as a fundamental pillar of international environmental law, particularly in addressing the climate crisis. This obligation derives from multiple sources of international law and has been consistently recognized by international courts and tribunals, given that impacts on the global climate system results from cumulative actions over an extended period. Not a single state can halt it, nor address its consequences in isolation. This duty finds its expression in Article 1 of the UN Charter, which commits states to achieve international cooperation in solving international problems of economic, social, cultural, or humanitarian character. The Charter obligation is further reinforced by Article 56, under which member states pledge themselves to take joint and separate action in cooperation with the organization to achieve the purpose set out in Article 55. In the environmental context, the duty to cooperate is reflected in foundational instruments, including the Principle 24 of the Stockholm Declaration, the Principle 7 of the Rio Declaration. Most recently, ITLOS characterized cooperation as a fundamental principle in the prevention of pollution of the maritime environment. The Climate Change Treaty regime provides specific expression to these cooperative duties without displacing broader obligations under general international law. The UN Framework on Climate Change preambles explicitly acknowledge that the global nature of climate change calls for the widest possible cooperation by all countries. The Paris Agreement elaborates concrete mechanisms through Article 7 on adaptation, Article 8 on loss and damage, Article 9 on finance, Article 10 on technology, and Article 11 on capacity building. The duty to cooperate, which emerged as a specification of the principle of good faith, is not merely a general obligation under customary international law, but requires specific content to be effective. This duty extends beyond formulating and elaborating commitments in multilateral framework agreements. And it is a continuing, nature cannot be satisfied by one-time act. The duty to cooperate is neither an aspirational policy preference nor an inchoate obligation lacking any meaningful content. In the climate context, this cooperation must primarily flow from developed to developing states and constitute an obligation for developing countries, particularly as regards the provision of technical and financial support. Meaningful cooperation in climate finance represents a necessary implementation of this duty. Moreover, this duty must be informed by the principle of common but differentiated responsibilities, which requires states to conduct consistent efforts to assist developing countries, which, with modalities of climate finance, must evolve to meet the urgency of the climate crisis and considerations of equity. Therefore, states cannot be said to have satisfied their duty to cooperate if they do so through financing mechanisms that place additional burdens on those already most vulnerable to climate impacts, or through processes that create de facto barriers to accessing necessary support. The duty to cooperate in the context of climate finance requires four fundamental transformations. First, access to climate finance must be simplified and expedited. The current bureaucratic barriers to accessing climate funds constitute a de facto limitation on developing states' ability to implement necessary climate measures. The duty to cooperate requires paying heed to the special needs of developing countries and ensuring that international cooperation enables effective implementation of treaty obligations. Second, as Bolivia emphasized at the COP29, climate finance must prioritize grants over loans and greater use of special drawing rights as debt-free financing options. This approach aligns with the established principle that cooperation must flow primarily from developed to developing countries and cannot be reduced to merely voluntary or solidarity measures. The obligations to provide financial resources represent an authentic interpretation by the parties of their obligations previously established in the climate change treaties. Moreover, the practice of providing climate assistance primarily through debt instruments effectively transferred the burden of climate actions to those less responsible for the crisis and undermines rather than respect the principle of common but differentiated responsibilities. Third, developing countries have an obligation to provide financial assistance, technology and support. The establishment and operationalization of the Loss and Damage Fund represent practical implementation of this obligation and constitute a core requirement. Fourth, the established obligation to cooperate requires meaningful participation and engagement in relevant processes. This obligation to cooperate meaningfully and in good faith includes participation in both technical and financial processes to support developing countries. In the context of climate change, this duty must be implemented in line with the principle of common but differentiated responsibilities, meaning states with greater capacity should conduct consistent efforts to cooperate with and assist other states in their fight against climate change. Mr. President, the plurinational state of Bolivia submits that the Court advisory opinion should recognize that the adequacy of climate finance in terms of both quantity and accessibility is integral to assessing compliance with international obligations regarding climate change. This includes both procedural obligation and substantive obligations to provide meaningful support. The implications are clear. Developed states cannot claim to be meeting their international obligations while maintaining systems of climate finance that are inadequate, effectively inaccessible for those most in need, or while imposing additional debt burdens on developing states for addressing a crisis they did not create. For the avoidance of any doubt, the duty to cooperate and the rules of state responsibility operate in a complementary rather than mutual exclusive manner. As evidenced by numerous states' submission, the existence of cooperative frameworks in the climate regime does not displace the application of the general rules. The complementary nature of this obligation is particularly evident in the context of climate finance. Voluntarily, contribution to cooperative mechanism cannot satisfy or substitute for the legal obligation of developed countries to provide compensation for harm caused by international wrong acts. As multiple states have emphasized, the distinction between voluntary cooperative mechanism and legally binding obligation of reparation must be maintained. The practice of cooperation through climate finance mechanism must therefore be understood as operating alongside rather than replacing obligations arising from state responsibility. Moreover, Mr. President, maintaining the distinction between cooperation and responsibility is essential for the effectiveness of the climate regime. If cooperative mechanisms were to be understood as displacing responsibility, this would undermine both the deterrent effect of state responsibility and the voluntary nature of cooperation. The Court should therefore affirm that while states must engage in good faith cooperation to address climate change, such cooperation operates in addition to, not in place of, their responsibility for international wrongful acts. Mr. President, members of the Court, that concludes my statement on behalf of the plurinational state of Bolivia. I should like to thank the Court for its careful attention.
I thank the representative of Bolivia for his presentation. I now invite the delegation of Brazil to make its oral statement, and I call upon His Excellency Luis Alberto Figueiredo Macato to take the floor.
Thank you. Mr. President, members of the Court, I am deeply honored to appear before this distinguished Court today. It's been Brazil's long-standing policy to support the International Court of Justice, to stand up for the rule of law in international affairs, and to embrace multilateralism and international cooperation to combat climate change. As we prepared to host next year the 30th Conference of the Parties to the UN Framework Convention on Climate Change, I take personal pride in representing my country in these proceedings, which aim to deepen our collective understanding of states' obligations regarding climate change. At the outset, I would like to thank the government of Vanuatu for the initiative of bringing this fundamental issue to the consideration of the Court. In these opening remarks, I will outline Brazil's perspective on climate change and the notion of historical responsibilities that underpins it. Brazil is acutely aware of the devastating impacts of climate change. Our people have been enduring extreme weather events, from severe droughts in the north to relentless rain and floods in the south. Intense forest fires have ravaged vital biomes such as the Amazon, the Cerrado, and the Pantanal. Sadly, these extreme events disproportionately affect our most vulnerable populations. Our vision for the next decades is deeply rooted in the principle of climate justice. At its core, climate justice seeks to combine environmental protection and social inclusion, ensuring that individuals, economies, and nature interact sustainably. On a global scale, it requires prioritizing the needs of the most vulnerable, those who have contributed the least to climate change but bear its heaviest burden, including indigenous peoples, traditional communities, women and children. This vision reflects the broader tenet of common but differentiated responsibilities and respective capabilities, CBDR-RC. Each nation must contribute to combating climate change in proportion to its socio-economic capacity and historical role in global emissions. Furthermore, to achieve climate justice, our collective action must address inequalities, both among nations and within them, leaving no one behind. Brazil, as a developing country, still faces significant socio-economic challenges. Ranking 89th in the Human Development Index, our primary focus remains eradicating poverty, hunger, and inequality. In 2022, 12.7 million Brazilians lived in extreme poverty, with government social programs accounting for 67% of the household income for this population segment. Despite these challenges, Brazil has demonstrated ambition and leadership. Last month, we unveiled a new and enhanced nationally determined contribution, NDC, pledging to reduce greenhouse gas emissions by 59% to 67% by 2035, compared to 2005 levels. This represents a 13% to 29% increase in ambition compared to our previously established 2030 target. Our range-based target allows flexibility to adapt to evolving economic conditions, international cooperation, and technological progress. Brazil's commitment, reflected in its new NDC, extends far beyond what could be reasonably expected based on our historical responsibility for global temperature rise. As a developing country with multiple economic and social challenges, we have nevertheless adopted an economy-wide absolute emissions reduction target. The ambition, scale, and scope of Brazil's effort reflect a level of ambition that often surpasses those of historically high-emitting developed countries. This is the ambition of a nation that faces much higher costs of capital and less fiscal space than developed countries to finance its just transition towards low-carbon and climate-resilient development. Mr. President, the issue of historical responsibilities has been a recurring theme in these procedures. I wish to address its scientific basis. The Intergovernmental Panel on Climate Change, in its sixth assessment report, acknowledges that global greenhouse gas emissions have risen sharply since the Industrial Revolution. These emissions have disproportionately resulted from unsustainable energy use, and land use change, lifestyles and patterns of consumption and production in developed regions. The warming we face today is predominantly the result of historical emissions accumulated over the last 250 years. According to science, the causality link between greenhouse gas emissions and global warming involves a three-step process. First, emissions increase atmospheric concentrations of greenhouse gases. Then, the higher concentration drives temperature rises, which in turn result in associated harm. However, this is not a linear process, but rather a dynamic interaction in which past emissions contribute exponentially more to current global warming than present-day emissions. Moreover, historical emissions have significantly depleted the remaining carbon budget, which is the amount of greenhouse gases that can still be emitted while limiting warming to 1.5 or well below 2 degrees Celsius as required by the Paris Agreement. IPCC has estimated that approximately 45% of historical greenhouse gas emissions remain in the atmosphere today. The unequal appropriation of the global carbon budget by developed countries not only creates new constraints to the economic and social development of developing countries, but also dramatically affects the livelihoods of the most vulnerable populations. Thus, the main provision differentiated between developed and developing countries, enshrined in the three core instruments of the climate regime, the UNFCCC and the instruments adopted thereunder, namely the Kyoto Protocol and the Paris Agreement, reflect not only different capabilities and circumstances, but also varying historical responsibilities. Climate justice demands that nations benefiting the most from historical emissions that still deplete the global carbon budget must bear the greater burden in addressing climate change. Mr. President, our legal advisor will take you through the main elements of our legal reasoning. He will comment on topics that may hopefully assist the Court in rendering its opinion. I must point out that legal issues not covered in this intervention, such as the strong relationship between climate change and human rights, cannot be construed as unimportant to us, or that Brazil agrees to a particular legal reasoning we are not commenting on. I would now most kindly ask you, Mr. President, to invite Professor Jorge Galindo to continue the presentation of Brazil's case. I thank you very much for your attention.
I thank His Excellency Luis Alberto Figueiredo Bocado. I now give the floor to Professor Jorge Galindo. Professor, you have the floor.
Mr. President, members of the Court, Brazil concurs with many states that the advisory opinion requested by the General Assembly through Resolution 77/276 raises issues of international law of paramount importance. These questions fall within the Court's jurisdiction, and we trust the Court will provide its invaluable guidance. In its written comments, Brazil stressed the centrality of the principle of common but differentiated responsibilities and respective capabilities to the advisory opinion to be delivered by this court and to the climate change international legal regime as a whole. Brazil views the CBDR-RC principle as the cornerstone of the international climate change legal framework. This principle underpins the UNFCCC and the two instruments adopted under it, namely the Kyoto Protocol and the Paris Agreement, ensuring equity in both interpretation and implementation. In many senses, it is the translation of the idea of historical responsibilities to international legal terms. The fact that many states in their written comments refer to it as the cornerstone of the regime or its core principle is not a rhetorical statement. Such comments represent a strong opinion juris that recognizes the centrality of the principle. The International Tribunal for the Law of the Sea, in its last advisory opinion on climate change and international law, was straightforward in recognizing the principle as established in the UNFCCC and the Paris Agreement thereunder as, and I quote, a key principle in their implementation, end of quote. The Paris Agreement states unequivocally, and I quote, this agreement will be implemented to reflect equity and the principle of common but differentiated responsibilities and respective capabilities in the light of different national circumstances, end of quote. It is clearly a principle paramount to the entire implementation of that agreement. The reason for differentiation in the Paris Agreement and previous treaties on climate change is more than evident. States have historically contributed differently to anthropogenic emissions of greenhouse gases and have distinct capabilities and resources to prevent and cope with the adverse effects of climate change. The Paris Agreement did not diminish the CBDR-RC principle. Rather, it expanded the ambition and commitments of all parties. Developed countries must take the lead, reflecting their historical responsibilities and greater capabilities. In this sense, developed nations which historically emitted the most greenhouse gases must lead by achieving net zero emissions earlier, investing in transformative technologies and providing financial and technical support for developing nations to fulfill their commitments. Brazil sees no reason why the court's case law on the obligations of states to prevent transboundary harm should not be applicable in the domain of climate change. These are undoubtedly due diligence obligations and thus obligations of conduct. Since due diligence obligations can only be understood on a case-by-case basis, differentiation among states must be considered while assessing the reach of such obligations. In other words, the CBDR-RC principle is widely applicable in due diligence obligations under the climate change international legal regime. We understand that the CBDR-RC principle does not exempt developing states from their obligations of due diligence. However, this does not mean that due diligence expected from developing states will be the same conduct expected from developed states. Differentiation still applies. In the history of negotiations of all climate change treaties, differentiation has always preceded the idea of setting international legal obligations. Once more, the International Tribunal for the Law of the Sea, in its advisory opinion on climate change and international law, properly understood the issue by stating that the implementation of the standard of due diligence, and I quote, may vary according to states' capabilities and available resources. Such implementation requires a state with greater capabilities and sufficient resources to do more than a state not so well placed, end of quote. This court's Pope Mills case corroborates such understanding of the International Tribunal for the Law of the Sea by referring to the term, and I quote, "the means at its disposal," end of quote, in its paragraph 101. Regarding the types of obligations a state has in the climate change international legal regime, Brazil wants to stress that these treaties also establish obligations of result. That is the case, for example, of Article 9.1 of the Paris Agreement, one that undoubtedly establishes the legal obligation of developed states parties to, and I quote, "provide financial resources to assist developing country parties with respect to both mitigation and adaptation in continuation of their existing obligations under the Convention," end of quote. This obligation is of the utmost importance for the Court to emphasize in its advisory opinion, especially considering that the recent COP29 once more showed the centrality of financial resources to tackle the harmful effects of climate change in all parts of the world. Mr. President, Brazil highlights that the core climate change international legal regime treaties are the UNFCCC, as well as the Kyoto Protocol and the Paris Agreement adopted thereunder. They fulfill different and complementary regulatory functions. Although a few states are not parties to the Kyoto Protocol, it is undeniable that those treaties were framed to form the basis of the regime. Obligations arising from those treaties are essential to tackle the harmful effects of climate change. The climate change legal regime must be understood and applied in an integrated and systemic way. It is a matter of fact that the Kyoto Protocol and the Paris Agreement were adopted under the UNFCCC. They support and enhance the core provisions of the Convention. It is self-evident that they do not replace the UNFCCC or revoke it. Quite the opposite. As set out in Article 2.1, the very purpose of the Paris Agreement is to enhance the implementation of the Convention, including its ultimate objective. Financial obligations by developed countries under the Paris Agreement are expressly, and I quote, "in continuation of their existing obligations under the Convention," end of quote, as I mentioned above. From Brazil's perspective, the treaties composing the climate change international legal regime provide for cooperation among states and establish a genuine duty of cooperation in light of the CBDR-RC principle. Such a duty may be found in several parts of the UNFCCC. Still, Article 4 of the Convention clearly shows how essential cooperation is to the fulfillment of all obligations of the climate change regime, both for mitigation and adaptation. References to cooperation in instruments such as the Kyoto Protocol and the Paris Agreement shall be read in light of the essential role the UNFCCC attributes to cooperation as a duty of states. Brazil would like to point out 4 remaining issues. We understand that the Court should address the following issues in its advisory opinion. First, it is time for the Court to recognize the legal value of at least some of the decisions of the conferences of the parties to the climate change international legal regime. They can at least constitute agreements and subsequent practice for the interpretation of the treaties composing the regime in the sense of Article 31.3 of the Vienna Convention on the Law of Treaties, one of a customary nature. Judge Charlesworth's opinion in the whaling in the Antarctic case before this court suggested such an understanding. Specifically, Brazil believes that the decisions of the COPs, which established, in light of the CBDR-RC principle, the need for developed countries to mobilize resources to address the adverse effects of climate change in developing countries, represent an authentic interpretation by the parties of their obligations previously established in the climate change treaties. Second, the use of specific terms in climate change treaties such as may or will is not the only factor determining whether provisions should be viewed as binding. Assessing the intention of parties while adopting those terms is essential to determining the binding character of a given provision. Third, Brazil is concerned about some states' growing use of climate change rhetoric to breach free trade obligations. In this regard, it is useful to recall that, according to the General Agreement on Tariffs and Trade, GATT, and the World Trade Organization, WTO case law, trade-related environmental measures must not, as a rule, result in discrimination between like products. On similar lines, UNFCCC Article 3.5 provides that, and I quote, measures taken to combat climate change, including unilateral ones, should not constitute a means of arbitrary or unjustifiable discrimination or a disguised restriction on international trade, end of quote. Fourth, although we recognize how complex causality-related issues are in climate change, Brazil has already proposed a methodological work to enable state parties to climate change treaties to quantify their national historical responsibility to global warming. Contrary to what some states argued, such a methodology is scientifically possible and feasible. In conclusion, Mr. President, Brazil wants to emphasize its full commitment to international cooperation and multilateralism to combat climate change. Our vision on the issue is grounded in the idea of climate justice, and we expect that the Court will contribute to making climate change a central topic to the rule of law in international affairs, taking into due consideration the importance of historical responsibilities for the climate crisis. Brazil reputes the CBDRC as a central legal principle to the whole international legal regime. Obligations in that regime must be of conduct, but also of result. While the UNFCCC, the Kyoto Protocol, and the Paris Agreement are the core treaties of the regime, the latter two were established under the first and must be interpreted in light of it. Furthermore, a duty of cooperation, especially from developed states towards developing states, is key to the regime. Additionally, Brazil expects that the Court recognizes that COP decisions, especially those related to the need for developed countries to mobilize resources to address the adverse effects of climate change, are at least subsequent agreements and subsequent practice regarding the interpretation of treaties. We also expect that the Court recognizes that intention, instead of the mere usage of some terms, determines the binding character of provisions in climate change treaties. The Court should also recognize that climate change may not excuse states from breaching their free trade obligations. Moreover, a methodology to assess past emissions is possible and feasible. Finally, Brazil avails itself of the possibility of responding to further questions posed by this Court in written form at a later stage. I thank you very much indeed, Mr. President.
I thank the President of Brazil for their presentation. Before I invite the next delegation to take the floor, the Court will observe a break of 15 minutes. The hearing is suspended.